Peaceful protest calling for more transparency in the Nolan Wells investigation was held Saturday evening in Mississippi. The parents are seeking answers about what led to the death of their son. Wells' body was found after a 4th of July boat trip with friends to Horn Island in Mississippi. The death has sparked speculation after his friends returned from the trip without him. Patrick Wright reports.
I feel like today's testament is that we want answers. It's not about vengeance. It's not about accusations. It's about the truth, and it's about transparency.
We're going to stand behind the family, and that's why we're out here.
No peace!
A lot of times, these stories go unnoticed.
Because Nolan Wells is not the only one. There has been a long historic string of young black men losing their life under very suspicious circumstances.
I am the family of Emmett Till, and my family is here in support of what's going on because this young man should not be dead.
No justice! No peace!
So I know him personally as a kid before he went off to college. It's hard in this generation to find kids that still say yes sir, no sir.
No!
His friends came back from the island. He didn't. And somewhere on that boat ride home, someone had his phone. Not lost, not forgotten. His phone. The one he was heard, on a recording that spread across the internet like wildfire, demanding back. His own voice, still alive, asking for something that belonged to him. And whoever had it, didn't give it back. By the time investigators arrived, Horn Island had already done what remote places do. The Gulf wind had moved, the tide had shifted, and a young man who had gone out to celebrate the 4th of July with people he trusted was gone, while everyone else who made that trip stepped back onto dry land and went home. A former judge, someone who spent years signing arrest warrants in Mississippi courtrooms, watched this case unfold and said publicly, under his own name, with his credentials attached, an arrest should have already happened. The question isn't just what happened to Nolan Wells on that island. The question is why the people who were there with him haven't been made to answer for it in a way that satisfies any reasonable legal standard. And that question is eating an entire community alive. If this is your first time on Midnight Evidence, hit subscribe right now and leave a like, because this case goes places most channels won't follow it. Stay with us. Nolan Wells grew up on the Mississippi Gulf Coast. By every account from the people who knew him, he was the kind of young man that communities quietly depend on, without always saying so out loud. He was respectful. He was self-motivated. He carried himself with a quiet seriousness that people around him noticed and remembered long after ordinary interactions had faded. A local business owner named Jiren Lowry had known Nolan since he was a child. Lowry's daughter played basketball with him when they were young, and years later, Nolan came looking for work at Lowry's business, a company that rented out water slides and bounce houses. Lowry recalled that when Nolan came to him for that job, he told Lowry that his parents had made clear he needed to earn his own money. That wasn't a throwaway detail. That was a window into how Nolan was raised and what kind of household he came from. Lowry remembered telling Nolan that he wanted him to make good decisions once he got to college, to set himself up for a lifetime. Nolan's response, according to Lowry, was simply, "Yes, sir." 2 words. Lowry said that kind of respect is rare to find in young people today, and that it reflected directly on the values Nolan's parents had instilled in him. That's who was on that boat. On or around the 4th of July, Nolan Wells joined a group of friends for a boat trip to Horn Island, a remote, uninhabited barrier island off the coast of Mississippi, sitting roughly 12 miles from shore as part of the Gulf Island's national seashore. There are no permanent residents on Horn Island, no stores, no roads, no cell towers in most of the area. The only way on and the only way off is by boat. The Gulf waters surrounding it are open, subject to weather, and unforgiving to anyone left without a way across them. The group went out together. At some point during that trip, something went wrong, and when the boat returned to the mainland, Nolan Wells was not on it. His body was found afterward. The exact circumstances of how and when he was found, and the precise condition in which he was discovered became the center of a growing and deeply painful public conversation, one that his family, his community, and eventually a former Mississippi judge all stepped into with questions that have not been answered to anyone's satisfaction. The Jackson County coroner confirmed that a physical examination of Nolan's body had been completed. At the time the community was gathering publicly to demand answers, the coroner stated that no preliminary indications of foul play had been found at that stage of the process. That statement traveled fast. But what traveled with it, and what matters enormously, is what that statement did not and could not mean. A preliminary physical examination is specifically designed to identify the most visible, most immediate signs of trauma: gunshot wounds, stab wounds, obvious blunt force injury, signs that announce themselves on the surface of a body without requiring laboratory analysis or extended forensic work. What it cannot tell you, what it is not designed to tell you, is everything else. Toxicology, subtle internal findings, chemical traces, evidence that requires time, equipment, and specialized analysis to surface. The coroner was also explicit that the complete final autopsy, including all toxicology results, had not yet been released and was expected sometime the following week. That is not a conclusion. That is a checkpoint on a much longer road. The protest was not happening in response to a confirmed ruling of accidental death. It was happening in the acknowledged space between a preliminary look and a completed picture, a space where the most important answers had not yet been given, because the most important tests had not yet finished. The community understood that distinction, even when public conversation around the case sometimes collapsed it. On a Saturday evening at the corner of Government and State Streets in downtown Ocean Springs, a crowd gathered. Estimates ranged from more than 100 people to several hundred. Whatever the precise number, the gathering was real, it was sustained, and it was cross-generational, in a way that said something significant about how far this story had traveled. Teenagers stood alongside grandparents. People who had never personally met Nolan stood alongside people who had known him his entire life. They held signs. They prayed together. A group known as Israel United in Christ marched down Government Street and returned to the crowd. The atmosphere, by all accounts, was peaceful and deliberate. Exactly what Nolan's mother had asked for. Christine Wells had spoken publicly the day before the protest. She asked people to keep things peaceful. She said her son did not like fights. She said he did not even like arguments. She told people not to come out trying to be tough, and she asked them instead to think about what Nolan himself would have wanted from any public response to his death. She said plainly, he would not have wanted that kind of behavior. That ask was honored. The crowd that gathered the following evening reflected the same values she described in her son. A 19-year-old named Nicholas Madison said his goal that day was simply to make sure people kept saying Nolan's name, and to show that young people understood their role in pushing for accountability in their own community. A woman named Quantig Green, describing herself as a mother of 2 sons, said the case had hit home for her in a deeply personal way, and that she wanted the family to know the community stood behind them. A Biloxi resident named Gordon Jackson said Nolan Wells could have been his own grandson, and connected the case to what he described as a long and painful historic pattern. A pattern of young black men losing their lives under suspicious circumstances in ways that too often go unexamined and unresolved. Jiren Lowry, who spoke from his own personal connection to Nolan, said something that cut through the noise of the entire public debate. He said this case is not about the color of anyone's skin. It is about the facts, whatever those facts turn out to be. And if what happened to Nolan was a mistake, then the people responsible should be willing to say so honestly and talk about it. What he wanted, more than anything, was for the truth to come out. He closed with a direct message to Nolan himself, telling him he had done everything right while he was here, and that he had done a good job of it. That is the community that showed up. That is what they brought with them to that corner in Ocean Springs. Not rage looking for a target, grief looking for the truth. At roughly the same time the community was gathering, a different kind of voice entered the public conversation, one carrying a very specific kind of weight. Carlos Moore is a former municipal court judge in Mississippi who now practices law out of Atlanta. He served on the bench for approximately 6.5 years. He has also stated publicly that he was ultimately removed from that position after speaking out against racial discrimination on social media while still serving as a judge. A claim that, if accurate, means he has already paid a professional price for refusing to stay silent when he believed something was wrong. He took to Facebook with a commentary that ran for more than 30 minutes. He framed everything he said around his own background, nearly a quarter of a century in the legal field, and years spent as the person actually signing search warrants and arrest warrants in Mississippi jurisdictions. He was not speaking as a commentator looking in from the outside. He was speaking as someone who had operated the very machinery he was now publicly criticizing. His clearest and most concrete legal argument centered on the phone. There was a recording, one that circulated widely, in which a voice, widely believed by those who heard it to be Nolan's, could reportedly be heard demanding his phone back. Moore's reasoning was direct. If that voice belongs to Nolan Wells, and if Nolan was alive when that recording was made, and if he was verbally and explicitly asking for his own property to be returned to him, then whoever had that phone was in possession of it against the expressed wishes of its owner, on a remote island, with no other means of communication, no other way to call for help, no other way to document what was happening around him. Moore said publicly, under his own name, with full awareness of what he was saying and who he was saying it to, an arrest should have already happened in this case. He named who he believed should be in handcuffs. And that is exactly where this story goes next. Before we get there, if you've stayed with this case all the way through, Midnight Evidence needs you to do one thing right now. Hit that like button and subscribe. The investigation is where the former judge's full legal argument comes out, and it is not something you want to walk into without context. A former judge, nearly a quarter century inside the legal system. A man who personally signed arrest warrants in Mississippi courtrooms, who knows exactly what it takes to put someone in handcuffs legally and lawfully, looked at this case and said, someone should already be arrested. Not for murder, not yet, for a phone. And that distinction, between the largest possible charge and the smallest, most immediately provable one, is where this entire investigation either moves forward or quietly dies. Because here is what former municipal court judge Carlos Moore argued publicly, under his own name, with full awareness of the professional weight those words carry. If Nolan Wells, while still alive, could be heard on a recording demanding his phone back, and the person who had it kept it anyway, that is potentially theft. Moore was not vague about this. He said that if an affidavit reflecting exactly that set of facts had been placed in front of him while he was still sitting on the bench, he would have signed an arrest warrant for theft of that phone, based on what has already been described publicly. No autopsy required. No murder charge needed. A narrow, specific, legally grounded question, sitting right at the surface of this case, waiting for someone with authority to pick it up. Moore drew a distinction that anyone who has spent time around serious criminal investigations will recognize immediately. He said investigators sometimes become so focused on building toward the largest possible outcome, in a case like this, potentially a murder charge, that they walk right past smaller, more immediately provable violations that are already supported by evidence available to the public. The theft question, in his analysis, does not require waiting on toxicology results or a completed forensic autopsy. It is a question that could theoretically be addressed right now, based on what has already been described in witness accounts and captured on video. That is a significant legal argument, and it deserves to be understood as exactly that. a genuine legal argument from a credentialed source, grounded in a specific and publicly documented piece of evidence, not a rumor, not social media speculation. A former judge saying, "Here is the law, here is the reported fact, and here is the warrant I would have signed." Moore's broader argument extended well beyond the phone. He said that nearly a week after Nolan was first reported missing, the investigation should already have search warrants on file, evidence formally submitted before a judge, and subpoenas issued for the social media accounts belonging to the friends who were with Nolan on that island. He said the young men involved should have been formally questioned by investigators, not approached informally, not spoken to casually, but formally questioned in a manner that produces sworn, documented statements. He framed this not as an aggressive or unusual demand, but as his understanding of what standard procedure looks like when a thorough investigation is genuinely underway. He also took direct aim at a specific choice of language made by the sheriff's office early in this case. Moore said he disagrees with the decision to publicly state that no foul play is suspected. His position is that the appropriate, accurate, and fair statement at that stage of the investigation would have been simply that it was too early to say either way. He argued that the language chosen, "no foul play suspected," shapes how seriously the public and potentially other institutions perceive the investigation. And he said the behaviors that had already been reported publicly did not support that level of certainty that early in the process. It is worth being precise here about what Moore listed and how to hold it. He pointed to reports that members of the friend group were seen having breakfast together the morning after Nolan went missing, rather than actively searching for him. He pointed to deleted and deactivated social media accounts. He pointed to an episode involving car keys, where one of the young men reportedly said he could not find them before they turned up shortly after. And he pointed to the fact that legal representation was reportedly secured very early, before Nolan's body had even been recovered. Each of those details has been separately reported by other outlets and has circulated publicly. What Moore added was his own legal interpretation, that these details, taken together and stacked on top of one another, cross a threshold from unusual behavior into something that should formally change how the friend group is classified within the investigation. That interpretation belongs to him. It is his legal opinion. It is not a finding from any judge, prosecutor, or investigator with actual jurisdiction over this case. And that distinction matters. This is also the point in Moore's commentary where the analysis requires the most careful handling. At one point during his remarks, Moore raised a specific question about one of the mothers connected to this case, noting that she had reportedly posted publicly that she had gone out to the island at some point. Moore openly speculated about why she was there, and used the word accessory in connection with her, while explicitly framing this as his own curiosity rather than a claim he could support with evidence. That framing does not neutralize the weight of the word. Wondering aloud whether a private individual might be an accessory to a crime, without evidence to support it, is a serious thing to put into the public record, even when it is labeled as a question. For that reason, this script will not name that individual. She has not been charged with anything. Speculation is not evidence, and amplifying an unproven allegation against a private person serves no responsible purpose here. To his credit, Moore was consistent and clear on one point throughout his entire commentary. He said repeatedly that he is not rushing to judgment and that the most serious possible charges, up to and including murder, must wait for actual evidence. He identified the results of both autopsies, the state's examination and the independent one commissioned separately, as the single most critical missing piece, currently standing between where this investigation is and where it could go. He said that evidence, combined with a thorough physical examination of Nolan's body for any signs of bruising or injury, alongside properly gathered witness statements in affidavit form, is what would need to come together before any judge could reasonably consider a warrant for something as serious as a homicide charge. Moore also walked through what happens procedurally, even after an arrest: arraignment, bail decisions, a preliminary hearing, a possible grand jury indictment, and ultimately, a trial requiring a unanimous jury verdict. He said his reason for laying all of that out was to manage expectations honestly. Even if an arrest happens tomorrow, he said, this would likely be a long process from that point forward. He was candid about the uncertainty embedded in that process. He noted that a hung jury remains a genuine possibility if jurors cannot reach unanimous agreement, and that prosecutors would then face the decision of whether to try the case again. He said the family may ultimately end up living with a verdict, whatever it turns out to be, rather than with the clean certainty they are currently searching for. Moore also raised broader institutional questions that go beyond this individual case. He asked publicly whether the Department of Justice's Civil Rights Division, the FBI, or the Mississippi Bureau of Investigation should take a more formal role, given concerns about whether local law enforcement can conduct a fully impartial investigation. He did not claim to know the answer to that question. He said it was fair to ask. He also invoked the name of Emmett Till directly, noting that no one was ever held accountable for that killing, despite what he described as overwhelming evidence at the time, and said he hopes that if the facts in this case do support charges, a jury in Mississippi today will give them fair and honest consideration. Moore was also personally candid about his own relationship with Mississippi as a state. He said he no longer refers to it as a great state, and said it is not a place he would currently recommend for raising a family, citing what he described as deep-seated racial dynamics that he experienced firsthand, including during his own removal from the bench. That institutional skepticism, coming from a man who operated within the system for nearly 2.5 decades, is not detached from the same concern driving the people who gathered at Government and State Streets in Ocean Springs. Both the crowd on that street corner and the former judge speaking from Atlanta are pointing at the same underlying question: whether this investigation will be pursued with the same seriousness and urgency it would receive if the circumstances were different. So here is where the case actually stands. A community gathered peacefully, several hundred strong by some accounts, to say Nolan's name and to ask that the truth be told, whatever that truth turns out to be. A former judge argued publicly, grounded in his own legal experience, that there is already enough documented evidence to support at least a narrow arrest related to the phone, and that broader investigative steps, warrants, subpoenas, formal sworn interviews, should have been underway long before now. And there are still no released results from either autopsy, state or independent, which Moore himself identified as the most important missing piece before anything more serious can move forward legally. What does not exist, and must not be treated as if it does, is confirmation of the more serious layers of speculation. Formal suspect classifications, accessory allegations against specific individuals, and conclusions about criminal intent all remain exactly what they are at this stage. One credentialed person's opinion, offered publicly and worth taking seriously as legal analysis, but not to be mistaken for established fact. There is a real symmetry in the two parts of this story worth naming clearly. A crowd of ordinary people showed up on a street corner, not because they had legal training or inside knowledge of the investigation, but because something about this case felt deeply wrong to them, and showing up in person felt like the only honest response. A former judge with decades of legal experience looked at the same publicly available set of facts and reached a strikingly similar conclusion: that the pace and posture of this investigation do not yet match the seriousness of what it is investigating. Neither the people on that street corner nor Carlos Moore have offered proof of what actually happened to Nolan Wells on Horn Island. What they have each offered, in their own ways, is a demand that the process itself move with the urgency this case deserves. A young man who said yes, sir, who earned his own money, who went out on a boat with people he trusted on the 4th of July, and did not come home. That demands more than a preliminary statement and a waiting period. It demands the truth. All of it. If this case matters to you, and after everything you just heard, it should, then Midnight Evidence needs you to do two things right now. Hit that like button and subscribe to the channel. We are going to keep following this investigation as the autopsy results come in, as the facts are confirmed, and as this case moves, or fails to move, forward. We will bring you those facts the moment we have them, and not a single moment before. That is the standard this channel holds itself to, and it is the standard Nolan Wells deserves. We will see you in the next update.